His appointment should not be disturbed.
Mr. Bhattacharya, you
Yes.
answered you also say that there is corruption.
No, I do not say that. I do not say in the given case.
Sorry,
Not at all.
You said, sorry, I correct myself.
Yes.
You said that in society there can be corruption.
Yes, yes.
You cannot totally eradicate it.
Not at all.
Why? Because it is the mind frame of the people.
That's right.
It is the mind frame of the people.
Yes.
I go to a place, I think
that by giving money I try to purchase a person.
No. If I give 10 rupees, I can complete my work within 2 minutes.
Yes.
If I do not give 10 rupees, then
this will not be done.
So then who are responsible? The persons who helm of affairs are responsible. So if the leader of the family says, give me some money, then I will do it for you. And if you fall a prey to that, you have to suffer the consequences.
No, I say that's a reason.
Ideally speaking, corruption, who is to be blamed? Government is to be blamed because they are conducting the selection process and dealing with fates of people who do not have the money to make their both ends meet. Now, if a person sitting at the helm of affairs says that yes, you give me something, I will arrange to do something. Suppose this
just
is
like the concept of quid pro quo.
Good, bad, indifferent.
Just like the concept of quid pro quo.
Now, his lordship says that prima facie you cannot rule out corruption. Why? Because there is CBI investigation. Your minister is in jail. Your persons on the helm of affairs have already been hauled up. At this stage, you cannot eradicate this finding that there had been no corruption at all.
I only add one thing. I was also in this thing exactly.
No, then how do the courts save the persons who have built up their families for 5 years having been employed?
Millard, I say, Millard, here I should be joining the issue.
We are wanting an answer on that.
That's
that is why we are eager to hear what they are wanting to say.
Right. Now, Millard, it is a well-settled thing that which my lords have laid, that long-standing, because these persons are working for a substantial time, and
that is another aspect.
The appointment should not be disturbed.
That is balancing of equities. That will come later.
Yes.
But the thing is, you have to satisfy us that, sir, I am not responsible.
Millard, my
friend might have given the money.
Millard, I only submit one thing, that there has to be some clinching evidence on record to establish that corruption has been done.
There are there are, subject to your submissions, there are instances or evidences on record that there had been corruption.
Millard, your
question is, it has not attained finality.
Yes, and
question
Millard,
is, it has not attained. It is under investigation.
The example of some honorable ministers. Millard, I do not name.
No,
now, has there been a proof of guilt? Has there been, supposing today, Millard,
there has been no finding of guilt. We are saying so.
Yes, there is no finding of guilt.
There is an investigation going on.
Yes, that is that is in a latent stage.
Right. So it
is in a latent stage.
So you satisfy us that this can happen in many cases.
Yes.
An investigation may be a fake investigation also.
Yes.
So maybe, suppose for one moment we say that the investigation as it is seen will not ultimately succeed.
Yes.
And before it succeeds, you are killing me.
Therefore, Millard, what I was submitting, what I thought over the case, I leave it for my lord's kind consideration and what the other members of the bar will be indicating to my lords. But kindly think, this thing, that, Millard, tangible evidence on record, but mere statements of any honorable judge, least to speak of, Millard, the order under appeal of the honorable judge who has, Millard, delivered the judgment. That has not been proved, which your lordship is indicating. And that is a sheet anchor of the matter. It is a sheet anchor of the matter. Yes, if there is a proof, then certainly, Millard, I should say that even then, if a person, Millard, makes submissions, he will be rather, Millard, making a misconduct on his part. So suppose after investigation, guilt is established. Yes.
You will come to High Court.
Yes.
Then you'll go to Supreme Court.
Yes.
In the process, 20 years will go.
Yes.
And your clients would be getting the benefit of 20 years.
They will be directed, my lord. The penal consequences will be imposed upon the. Kindly see, and the fallacy of the law. Fallacy of the law that cannot be cured.
All right. Thank you, Mr. Bhattacharya. Yes, who is next in line?
And Millard, so far the appointments should not be disturbed. I got 3 judgments. I am just giving the reference. I have yes. Millard, 2009 volume. This is only how to balance equities.
2009
Volume 1, SCC.
Yes.
768.
Yes.
Paragraphs 53 and 54.
Yes, 53 and 54. Which is the other judgment?
53, 54. Then 2001, volume 3 SCC 328.
Yes.
Paragraphs 5 and 6. Then AIN 1998 Supreme Court 3268. Paragraph 3268.
Yes.
Paragraph 6.
These are on balancing of equities.
And the doctrine of comparative hardships.
Paragraph 6.
Paragraph
6 last.
Therefore, my lord, having regard to the facts of the case, I very respectfully submit that, my lord, in respect of the candidates
Yes.
who are working, kindly consider that their appointment should not be disturbed.
Yes.
Your lordship may, my lord, even my lord, if your lordship may I go a stage further, your lordship may impose some conditions that if it is proved in future, insofar as the training qualification, or insofar as these particular teachers are concerned, that there has been a corruption, then certainly they can be put to task. Otherwise, what is the situation now, Millard, in the School Service Commission matters? The persons whose appointments have gone, Millard, they are committing suicide. They are doing something which cannot be, Millard, expressed in words. It is not a political jugglery. It is a matter wherein, Millard, the particular problems which has been emanated, that has to be solved. Court acts as a guardian. Court does not institute or does not aid of giving, my lord, protection to the political persons.
Yes, thank you.
I'm grateful to my lords. My lord, this is an extreme. My lord, only thing, if in reply something is required, kindly give me, my lord, some time.
Every day we are repeating.
No.
I want to hear that.
My lord, your lordship has given me enough time.
Thank
what
you.
I, my lord,
Yes,
require.
Mr. Mojumdar, you are appearing for appellants in?
Yes, madam. I am giving the details. আজকের নাম্বার কত আছে?
You are in appellants in?
Appellant in MAT number 1383 of 2023. The appeal was admitted on 6th of...
Only one you are appearing in?
No, 2 appeals, madam.
Another one is?
Another one is, madam, 1409 of 2023.
1409 of 23. Acha, in respect of 1383, petitioners are from which district?
Madam, several districts.
Several districts. When was
Madam, the appeal was admitted on 6th of September 2023. Both the appeals, in fact.
And in the other appeal?
And I am representing in total about 1600 candidates who are working now.
All teachers,
all teachers, no para teachers.
And in MAT there are how many applicants?
No, total.
Both the
in MAT 1409, to be precise, 669 candidates, and MAT 1383, 973 candidates. So it is in excess of my lord 1600.
In a one is 973. One is 973 and the other one is
973 in in math 1383 and 1409 it is 669.
Very good. Yes, yes.
My lord,
669 and 973.
33.
Yes.
May I start? My lord, I have read
একটু বের করে
here. What?
that was the case of the petitioner.
That was the case of the petitioner, my lord.
Now here it starts in course of hearing a serious
That is
allegation.
what I am submitting. So,
This
my
is
lord,
an
the case
allegation.
of the petitioner which was made out in the writ petition or canvassed before the honorable single judge as on 20th December 2022, my lord, it was their case that aptitude test was held as recorded by the honorable single judge. On 17 January 2023, my lord, then there is another recording which says that no aptitude test was held. Now, my lord, the honorable single judge decided to exercise my power under 165 of the Evidence Act and asked some questions after administering oath to 7 of such candidates.
Now, apropos this, what was the averment in the writ petition?
Regarding aptitude test?
This contrary statement which you are showing.
Nothing. There is no aptitude test, no averment.
So we are wanting.
Yes, absolutely, my lord. It's a very pertinent question.
So as per you, there was no averment that no aptitude was held.
Absolutely. We bow down to your lordship. So, my lord, we find 7 petitioners were being picked up and they were asked to depose. My lord, I will be making a submission during the course of my hearing that this exercise, this inquisitorial exercise of under section 165 could not have been carried out in judicial review proceedings. And I would rely judgments rendered by the Honorable Supreme Court for that purpose. There is no dispute, there is no cavil to the proposition of law that section 165, just pausing here for a moment, section 165 is perhaps a statutory imprint, my lord, which basically embodies inquisitorial process in adversarial system. For that, my lord, I think, my lord, nobody would have any objection because that is the law. Now, my lord, kindly come to page 422. How the trouble started, my lord. From their evidence, this is the key factor in this matter. This is on 17th of January 2023. From their evidence, I am satisfied there was no aptitude test for the petitioners. So 7 petitioners being examined, an allegation or a recording of the case made out by the petition is made on that day that aptitude test was not taken, and they depose that no aptitude test was taken. And my lord, the honorable court, on the basis of the statements, well, at that stage, my lord, no recording of statement was made, or the interviewers were not invited. So at that stage, the honorable single judge forms an opinion that no aptitude test was held so far as these petitioners are concerned. 7 petitioners from different districts. The learned advocate for the board has submitted that he does not have any idea whether any aptitude test was taken or not. Well, he had to take instruction. Now, my lord, comes the next order. These 3 orders are the key orders, because I will not trouble your lordship with the entirety of all the orders. Lordship has heard us, and I don't want to detain your lordship unnecessarily. Page 423. I directed the petitioners that at least 2 candidates from each district are to be present before this court, as the court wants to know from them about the interview and aptitude test taken by the board in 2016 selection process. I am told by the learned advocate for the petitioners that the candidates are present. Now I start exercising my power under section 165 of the Evidence Act, as I want to take evidence of the candidates from each district. Some names from each district have been intimated to me by the learned advocate for the petitioners who were the candidates in 2016 recruitment process and appeared before the interview board, but all of them are unsuccessful. Well, then Shankar Thamba is one of the candidates who did not appear. Then, my lord, the deposition was taken. Kindly take, my lord.
Shankar Thappa was an interviewer.
No. Candidate, right? Candidate. So,
Well, Mr. Partha
Mala, that's a mistake. He's not an interviewer.
So Shankar Thappa was a
candidate who is also a petitioner. Petitioner.
He left, na? You should have caught him.
Or, my lord, he thought that, my lord, if he makes a statement which will go against the perception of the court, then what happens?
Yes.
In fact, one of the candidates was examined at petitioner, and it was found by the honorable single judge that the statement or the deposition of that candidate, I'll give the names shortly, my lord, that was not a very correct stand. Then I take your lordship, my lord. This is very interesting. Page 425. Now at this stage, when evidence of large number of petitioners have been taken, so 19 plus 7 is equal to 26, and there are about 139 petitioners, and the honorable single judge is of the view evidence of large number of petitioners have been taken, which are throwing light upon one of the allegations of the petitioners. I will not allow filing any affidavit in opposition in this matter by the board. But subsequently, I think board was allowed that. Point is not that. Point is that the honorable single judge thought, after examining 26 writ petitioners out of 139 writ petitioners, examination of large number of the petitioners have been done. Let us take the figure of 26. If your lordship kindly takes the figure of 26, this is very interesting. They were about 1,25,000 candidates, subject to correction, who participated.
There are 30 petitioners who
30 interviewers were examined. 26 petitioners were examined. 30 interviewers, 26 petitioners. Well, I have prepared a table, a very short table, which will give the entire picture. Correct? So, my lord, 30 petitioners, 30 interviewers, 26 petitioners. Let us take the figure. If we take the figure of
30 interviewers and
26 petitioners
were examined
in total.
Yes.
Well, my friend suggests that I continue next day and not to bother your lordship.
But we are not suggesting, Mr.
But my lord, this is a compulsion which we have. What can we do?
Please finish off this.
Yes, my lord. I take your lordship just this part. Approximately 1,25,000 appeared for interview. Again, correct me if I'm wrong. Well, I will stand corrected. By
1
Mr.
lakh,
Tiwari, in fact.
1 lakh,
25,000 appeared. Out of which, my lord, this 1,25,000 included trained and untrained candidates. Correct me if I'm wrong. Right. About 40, in excess of 42,000, including trained and untrained candidates, were given appointment. In fact, 42,800 and odd. Right? 863.
886.
863, my lord. Something like that, but 800, in excess of 800.
Appointed.
Appointed, trained and untrained.
Hmm.
And also including, my lord, para teachers, ex-servicemen, etc., etc.
Hmm.
That is the horizontal part. And my lord, out of 48,800, about 32,000 were untrained candidates. Which, my lord, the honorable single judge recorded 36. My lord, that was a
And
mistake. That
corrected.
was corrected. That's not nice. That's nothing relevant. What I'm on is that
About 32,000 were untrained.
32,000
32,000
were untrained.
untrained.
Untrained. Untrained. So, my lord, we come to a figure which is very interesting. If we take 26 number, it is actually 0.0208% of the total candidates. 0.0208% of the total candidates.
Hmm.
And my lord, the honorable single judge, well, I will demonstrate, I will prepare a table, bases his lordship's judgment. With due deference to the honorable judge, my lord, extreme highest regard for him, I have. My lord, went wrong. Went wrong. Highest regard for him, my lord, highest regard.
Yes.
So, my lord, this is the facts and figure. Kindly allow me, my next day I will be placing the table from how this has happened. And my lord, I will also continue. Whenever your lordship would ask us to come.
Who else is there on your line? You and Mr. Chagor. Huh?
My lord, this is one big happy family, my lord. Don't abandon us. Both sides.
You are not leaving us happy. We are becoming unhappy day by day.
We will address the specific questions.
Specific questions. Specific
The
questions.
corruption.
Corruption.
No, Bhattacharya said he would be taking 15 minutes.
My lord, that I anticipated that he will be taking 15 minutes.
So, if
So, my lord, if by Mr. Bhattacharya's standard, my lord, I have something to say, my lord.
এ জীবনে শেষ হবে না।